from my,
Number one,
from the petitioners, your lordship.
this item number one, just give me. Item number one. Most probably on the last occasion also, you have given 4 weeks time.
Yes,
To
yes.
take instructions.
Yes, not instruction, but regards to the committee that has been set up to decide on the issue, the matters of the petitioners. Your lordship, the committee is yet to take a decision on that. So if some more time can kindly be granted to us, my lord.
So you are additional AG.
No, your lordship, I am the senior government advocate. Additional AG is representing the other
For
respondent.
the other respondents, your lordship.
You're for the other response.
Yes, lordship.
So from the petitioner side, you are appealing.
Yes, your.
So you are representing whom? Government advocate, you are representing,
Respondent number one.
you are representing one.
Yes.
And 2, 3, 4, 5, you are
Yes,
representing.
yes, lordship.
So they are again seeking 4 weeks time. Do you have any objection?
No objection, your lord.
So as per the last order, the committee has already been constituted.
Yes. The committee has constituted, but your lordship, they are seeking for information from all over the department, so they are taking some time, your lordship.
Mr. So-and-so, the learned counsel for the petition. And also heard MS, you are MSV,
Shukri.
Sokri, the learned additional AZ, Nagaland. And also heard Mr. So-and-so, the senior government advocate appearing on behalf of respondent number one. It is submitted that the committee has already been constituted, but the committee is talking with the other departments also in regards to the contextual employees payment. The issue is there, na?
Yes.
As to the payment of the minimum scale to the contextual employees. He submitted that it needs 4 weeks time to take proper instructions from the committee consent. That's from the consent committee. Prayer allowed, list after 4 weeks.
Much
This is a matter of 22, so just try. This is a matter of 2022.
Yes,
the
yes,
petition
lordship,
is.
yes.
So try to get instructions by 4 weeks time.
Yes, lordship. Lordship, I beg to mention item number 6. Lordship, here I have instruction to appear on behalf of the sole respondent. So can you allow me 4 weeks time, your lordship, to obtain the instruction? I've taken the consent of the petitioner, your lordship.
In item number 6.
Yes,
In item number 6. Item number 6. So you're going to appear for the
for,
item.
yes, for the sole respondents.
It's a sole respondent.
Yes,
You're for the petition? Yes. Hard MS so for the appear for the petition. And also hard Mr. MSV Soki, the learned additional AZ, Nagaland. And is submitted that she has already taken instructions and going to appear representing the sole respondent. So now you want to take, after instruction, you are going to file
Yes.
any?
we may file a review of this petition, your lordship, yes. So,
Affidavit in opposition.
lordship, right now, let me take the
Instructions.
instruction, your lordship. So 4 weeks time may
She
be
needs,
granted to you.
and submitted that she needs 4 weeks time to take instructions from the authority concerned. Prayer allowed, list accordingly after 4 weeks.
Much
May I please, my lord? Lordship, I beg to mention item number 5.
Yes,
Lordship, in this matter, your lordship, I have instruction to appear for respondent number 1, 2, 3, 4, and 6.
1, 2,
5,
1, 2, 3,
4, and 6, your lordship.
4 and 6.
Lordship, I'm appearing for respondent number 5.
5 is a private respondent?
No, Lordship, accountant general. Principal-
Accountant general.
Yes.
In 3 weeks' time, may kindly be granted to receive necessary instruction, my lord.
So that means the service is already complete.
Yes, yes.
You are for the petition.
Yes, Lordship.
It's all no problem.
Her name is so-and-so, appearing on behalf of the petitioner. And also her Mr. so-and-so, the learned senior government advocate. Appearing on behalf of respondent number 1, 2, 3, 4, and 6. And also heard Mr. So-and-so, the.
And Mosoi.
And
Respondent number 5.
5. And so-and-so, the appearing on behalf of the respondent number 5. 5 first. It is submitted by Mr. So-and-so, this learned senior government advocate, that he needs how many?
3 weeks time.
3 weeks' time to take instructions from the authority concerned, and the learned counsel appearing on behalf of respondent number 5 also.
Lordship, here I will not be filing any affidavit because, Lordship, the matter pertains to regularization.
Okay,
So as an AG, Accountant General Office, unless they finalize the whole matter, we cannot process the pension. So it's a pension matter. So we have nothing.
so
to
you
say.
are not going to file any?
No, Lordship.
Okay. File any so-and-so. Heard a prayer allowed, list the matter accordingly after 3 weeks. Okay, we are listing it after 3 weeks.
Obliged, Lordship. Obliged.
May I please, Lordship? Lordship, I beg to mention item number 12. Lordship,
Mm.
my senior advocate, PJ Soikia.
Mm.
He have some personal difficulty today, so kindly list the matter on 9 September.
So it was earlier the fixed matter, in fact.
Yes, your Lordship, but he has some personal difficulty.
So you are appearing for the respondent number,
Lordship, I'm for respondent number 2, Your Lordship.
you are for the respondent number 2.
Yes.
Huh?
I'm for respondent number 1.
Your PP.
Lordship.
Her name is so-and-so. And also heard Mr.
Metofero on behalf of Lima Wapang.
on behalf of Lina Bang,
Lima Wapang, Lord.
appearing on behalf of Lina Bang for the respondent number 2. And also heard Mr. So-and-so, the learned PP, appearing for the respondent number 2. It is submitted by MS so-and-so, appearing on behalf of the senior counsel, Mr. P. Saikia, that due to some personal difficulty, he is not in a position to attend the court and accordingly paid for prayer allowed. List the matter, you want to fix it on 9th September.
Yes, your Lordship.
So now this will fix the matter we fixed. So just try to get it.
Okay, your Lordship.
9th September. No?
Yes, your Lordship. Lordship, there's interim, so interim may
Interim
continue.
is there.
Yes, Lordship.
Interim will continue till next date of listing.
No, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 13, 14, and 15, Your Lordship. Analogous matter.
These are all connected matters.
Yes, analogous. Lordship, here the leading counsel is I. Rafiq, Lordship, from Gauhati, Lordship. Lordship, I've been informed by him that his mother is not keeping well, and he's not keeping well, and is hospitalized, Lordship, so he cannot.
So
Appear
along
today.
with these 3 criminal petitions, 1 AB is also there.
Yes, Lordship. Lordship, so,
I repeat, he is supposed to come from Gauhati,
yes, Lordship, but yes, difficulties today, Lordship.
but in one criminal, 13, 13, 14, and 15. No?
Yes, Lordship.
So who are the respondent? Have you informed the respondent?
Yes, Lordship.
Yes, your Lordship. Respondent in item number 13 and 14.
You are for the item number 13 and 14.
Yes, your Lordship.
And 15 PP is appearing, I think. In fact, it is a AB, and have you received any case diary and all? Is it required? No idea.
On the last occasion, Lordship, I have raised the case that
Case diary was called for earlier.
earlier it was not called for. Since there was a criminal petition which was still pending before this.
No, in those 2 criminal petitions also, the case diary is required or not?
Lordship,
It's required. So
No.
have you called for any?
Lordship.
It's not here anything. It's because I'm asking you, these are all connect, I mean, the analogous matters. So
Lordship,
1 AB is also there.
Lordship.
So for disposal of the AB, most probably CD may be required, I don't know. If it is required, then it's okay, otherwise. In other the criminal matters also, the criminal petitions, the CD is there or CD is required or it's not required.
It will be required, Lordship.
CD is required.
Lordship.
Is it called for or not yet?
Lordship,
Have go to the case record then. Heard Mr. So-and-so appearing on behalf of Mr. I. Rafiq, the learned counsel, and it is submitted that due to his mother's illness, he is not in a position to attend the court and accordingly paid for an adjournment. The learned counsel appearing on behalf of the respondent, MS so-and-so, raised no objection. And in the meantime, the Mr. So-and-so, your Mr.
Dijumon,
Biju,
Dijumon.
Bijumam, the learned PP also raised no objection. List all the matters accordingly. Have you any date to what any?
Your Lordship, if the matter could be fixed on 5th September,
5th of September,
yes, Your Lordship.
it all the matters be fixed on 5th September. Was there any interim
Yes, Lordship, there is an interim, Lordship.
in criminal, both the criminal petitions or in
I think
AP also?
13 and 15, Your Lordship.
In 13 and 15?
Yes, Lordship.
In 13 and 15, there are, that means in the AB also you have one interim
Yes,
order.
yes, I'm protected by that AP, Your Lordship.
Then let me give her the item number 15 you have given here. Which one? This is 13, this is criminal petition. Yes, yes, AB, yes. Oh, it is a case wherein the order of thing was passed by me, na?
Yes, Lordship, on
By
principle.
this court only.
Yes.
Okay, on 22/12/2023, there was a. So do you have any idea with the strength of this interim order, which was passed most probably from the principal seat? The accused appeared already, cooperated or not yet?
Lordship,
Because the
that's-
continuous say the order is continuing
Yes,
since 22/12/2023.
Yes, sir.
Today is, now we are on the month of August.
Lordship,
So long 7-8 months it is continuing.
Lordship.
Whether do you have appeared, do you have any instruction? No, nothing. Then why don't you call the case diary now? It will reveal everything. Interim continuation, interim will not do now. Interim to continue corridor in 13 and 15.
Lordship.
Otherwise, it will be dismissed if he is not yet appeared.
Lordship.
Even after the order was passed on December 2023.
Lordship,
If it is not yet appeared, then automatically it will be cancelled.
Lordship.
On next day, you try to call for the case diary, Swiss PP, you try to call for the case diary, see the progress of the investigation, what is happening. If it's just training, giving, I mean, opportunity interim order, if it's roaming here and there without appearing before the concerned authority, then what will do? Take the instructions.
Lordship. Lordship.
5th, you are saying 5th of September?
Yes, Your Lordship.
Today the matter is 5th of September.
May I please, Your Lordship. Lordship, I beg to mention here in item 9. Lordship, my senior has some difficulty, so can you list it after 1 week?
Here, Mr. Here only this thing is shown. This one, he is not appearing till now. This one also, his name is not shown. She is for the petitioner, I think.
Yes, Lordship.
The respondent, who is
None appeared till date.
none appeared.
Yes,
But the case is listed for hearing only.
yeah.
How? Because it is an arbitration matter, no? 21 on 22. Rusty was there, I think. No? You have already filed an affidavit in that regard regarding the service of notice. Hard MS so and so appearing on behalf of so and so. What is the problem of your senior?
Pardon?
What is her problem? His or her, I don't know.
My senior has some personal difficulties. Medical.
They go to do hearing. So when do you want?
After 1 week.
List after 1 week. Okay.
No. But
May I please, your lordship? Beg to mention item number 16, your lordship.
1/6.
Your lordship.
Ah.
Your lordship, here, the leading counsel, he have some personal difficulties, your lordship. If the matter can come up after 3 weeks, your lordship.
Who is your leading counsel?
The counsel, S. Hafik, your lordship, he's from Gauhati, your lordship.
S. Sigdar.
Hafik, your lordship. The first one, your lordship,
Ah.
in the cost. Lordship,
S. Hawk.
lordship. If the matter can come up on 27, your lordship, of this month.
Government. You are appealing for
For the
the,
state, your lordship.
for all the respondents or?
Your lordship,
For
for
hearing,
the, for respondent number 1 only.
For the respond number
1.
2251.
lordship,
the
consent have
person
been taken from the private response, your lordship.
You have taken consent
Lordship.
with the consent of the other side. The learned counsel appearing on behalf of Mr. S. Hawk for the petitioner, plead for an adjournment stating that Mr. Hawk could not appear before the court due to some personal difficulty. MS, you are MS?
S. Mary.
As Mary, the comment advocate appearing on behalf of respondent number 1, raised no objection. List accordingly up to when you want.
27, your lordship.
27th of this month.
This month, your lordship.
It's okay for you?
Much obliged. Lordship also beg to mention item number 7, your lordship, for orders.
Item number?
7, your lordship, for orders, your lordship. Your lordship, in the last interim, your lordship, the petitioner was allowed to make amendment, your lordship, by filing an application, your lordship. Application has been filed, your lordship. If the matter can come out after 1 week, your lordship.
Yes, for amendment was there, I think. no?
Yes, your lordship.
Those amendment, whatever, you don't have any objection there.
No.
Lordship, the application is yet to be listed, your lordship. If the matter,
No, listed in a case. I
Lordship.
don't know. You have already filed the amendment petition or not yet?
lordship, we have filed last,
Today only.
yes, your lordship.
When you have filed today?
Yes, your lordship.
Or Mr. So for the petitioner, and this is submitted that the amendment petition has already been filed. Which it is restricted to amendment petition has already been filed today in person to order dated 26/7/2024. Post op. Also heard Mr. So the learned senior. You are here also, you are appearing as a, on the strength of the comment advocate?
Yes, your lordship, only for respondent number 1.
For the response. So, please no objection. List matter regularly after 1 week it will be
Lordship,
listed. List after 1.
Much obliged.
Obliged, my lord.
Have you furnished the copy? Mr. Have you furnished the copy to the other side?
Also, a
Copy
copy,
you
your
have
lordship.
furnished?
Lordship also furnish a copy, your lordship.
You have
In the
also
course of the
furnished.
day.
Should furnish the copy during the course of the day. Okay.
Obliged.
May I please, your lordship? I'm appearing for item number 3.
Yes.
Your lordship, service has been completed and LCR has also been received. So may this matter be listed for admission hearing on the first week of September.
I don't know, but the matter is fixed for admission hearing it only today.
Okay,
also.
okay. My
The
senior is
admission
indisposed, your lordship.
Service is already completed, yes, so that's why most probably is appearing. for
Yes,
the-
your lordship.
So here, from the government side, have you filed any?
No. Not required, no.
Not required. So you are appearing for
3, 4, and 5.
3, 4, and 5. 3, 4, and 5, and you are for
Respondent 1 and 2.
correspondent 1 and 2. 1 is number 6 is the pro forma. And for
Lordship.
pro forma also you have taken steps?
Yes, your lordship.
Okay, the stay is also there. no?
Lordship,
One stay order is also there.
yes, your lordship. And lordship, if I may, there's two similar matter relating to this, civil revision 10 and 11. So can
Just
it be
wait.
maybe take along together on the next date?
Pardon, so and so appearing on behalf of, you are appearing on behalf of Mr. C.T. Jamir.
Yes,
senior
Your Lordship.
advocate. And also heard MS so and so, the government advocate appearing on, the additional AZ, Nagaland appearing on behalf of respondent number 3, 4, and 5. 3, 4, and 5, and MS so and so appearing for the respondent number 1 and 2. It is submitted by MS so and so that the service is already completed. Answer has already been received and matter may be listed for admission hearing. But it is seen that matter is already listed for admission hearing. However, considering this submission made by so and so, matter may be listed for admission hearing. Along with, yes,
Civil revision 10 and 11.
along with civil revision
10.
9/2022 and civil revision criminal, one civil revision, 9/22, along with criminal
No,
revision.
no, your lordship, it's not listed today.
It's
Huh?
not
It's
listed
not listed
today.
today.
There are three
Oh,
analogous
three
matters,
analogous
only
matters.
one matter listed today.
Oh,
Yes,
this
Your
10 and 11
No,
is
no,
not
no,
constant.
no,
Okay,
no,
okay.
no.
What are the numbers? One is
10 and
10
one
of
is
the
11.
10
2024
2024.
and 11 of 2024.
May be listed along with civil revision 10/2024 and 11/2024. List after 2 weeks will do.
Your Lordship, if possible on the first week of September.
It's a matter accordingly on the first week of September. So you are not on 10 and 11 from this pause list. I thought you have.
No, no, Your Lordship,
for
my
10 and 11.
my
Okay.
apologies.
Much
Lordship, there's an interim.
Interim be continued till next date.
Much
First week of
obliged.
September, it will be continued.
May I please, Your Lordship? I'd like to mention item number 8. I'm appearing on behalf of my senior CT Jamir. He's currently indisposed, so if the matter may be listed after 3 weeks.
Who are you for the petition?
Lordship,
Do you have any objection?
no lordship.
Heard MS so and so, the learned counsel appearing for the petition, and also heard MS so and so appearing on behalf of Mr. C.T. Jamir, the learned senior advocate, and paid for an adjournment stating that he is in disposed condition. So when you want, after 2 weeks,
3 weeks.
list the matter after 3 weeks. Okay.
Much obliged.
May I please, your lordship, for item number 16, your lordship, there's an interim, your lordship. If
In item number 16.
16, your lordship, if the interim may continue, your lordship.
Item number 16, interim be continued till next date.
Lordship, much.
For admission, item number 2.
May I please, your lordship.
Yes.
Lordship here, the leading counsel, your lordship, UK what your lordship.
Hmm.
You have some personal difficulties, your lordship. He's from UP, your lordship. It seems there was some
He's from?
difficult UP, your lordship, Uttar Pradesh, your lordship.
Uttar Pradesh.
There was
So
some
he is
difficulty
going
in
to appear personally or through BC?
lordship will appear personally, your lordship. If that be fixed, your lordship. It seems he
It was
was,
fixed only.
your
today.
lordship, he was unable to get the ticket, your lordship, this time, your lordship. If the matter can come up on September, your lordship, first week of September, your lordship.
Your lordship, if the, since the council is from outside, it's better to fix a date and I'll suggest either 22 or 29 of this month.
You are representing the government advocate, government,
No, your lordship, I'm for respondent number 2.
the private respondent?
Yes, your lordship.
heard Mr. Swenso appearing on behalf of Mr. B.K. Upadhyay, and also heard Ms. Swenso the appearing for the respondent number 2. It is submitted by Mr. Swenso that Mr. B.K. Upadhyay, the engaged counsel, who is going to appear, he is from UP, and due to some personal inconvenience, he could not appear before the court today, and accordingly prayed for a fixed date. Accordingly paid for an adjournment, and they also requested to make a fixed date. In that case, you want to fix it on 22.
Yes, your lordship, either 22 or 22nd. 22 is 2 weeks and 29 is 3 weeks.
Lordship, if the matter can come on September, your lordship, there will be difficulties, your
Lordship,
lordship.
this has been going for quite a long time, and
Yes,
yes,
obviously.
your
So
lordship.
I agree to that, your
Kindly
lordship.
either 22nd or 29.
But your
Make it
lordship,
on 22nd or 29. Today,
Lordship,
he was
yes,
supposed to
Lordship,
come, but
please.
yes, your lordship.
as you have submitted it, he did not, could not,
Lordship, your lordship,
due to some ticket problem.
I was informed that I've already got ticket for September, your lordship. Lordship, there is
Which date, September, which date?
second, your lordship.
2nd of September.
2nd of September, your lordship.
Then
Your
let us
lordship,
give
no,
1 month.
kindly
Lord-
fix it either on 22nd or 29. 29, okay, then we can go for 29 if your lordship can kindly allow that.
Lordship, there will be difficulties, your lordship, and your lordship, the council is unable to appear through PC also, your lordship.
No,
So
no,
he wants to come
whatever,
person
if he has
physically,
not
Lordship.
already, suppose, I don't know whether.
Yes, your
he-
lordship, I agree, your lordship.
29, you can take it on,
Yes, your
otherwise.
lordship.
Lordship, second, your lordship. Let it, second, your lordship.
let's
Your
rather
lordship,
than
I have
give
to
this-
consult my senior counsel for that. So I think 29 is fine, your lordship.
Lordship, if 29 is
29,
also fixed, your
either,
lordship.
we are giving them options, either 29 or
Just inform
22nd.
us then.
Lordship, if 29 is also, it's fixed, your lordship, he will be unable to come, your lordship. That's the difficulty, your lordship. Just 1 2 days, your lordship. 29, 30, 31, just 2 weeks.
Either
days
29 or
difference,
30 then, your lordship.
Let's take it, take it time to renew and then ask, let us inform
Lordship.
us.
Let me-
Date to blank side.
For admission, item number 4.
Yes.
May I please, your lordship? Your lordship, this is an bail application under 439 of the CRPC. The offenses booked under this section are 366 and 4 POCSO Act. Your Honor, if I may be allowed to narrate a brief facts of the case. The brief fact of the case in a nutshell is that, Your Honor, by your lordship, an FIR, a written FIR was filed by the complainant, who is the brother of the victim.
Before starting this one, I just want to ask you whether the service is already completed on the, who is the respondent number 2?
Yes, your lordship.
Already complete, you are appealing?
Lordship, yes.
Okay. Yes, yes, you can continue.
A written FIR was lodged on 11/11/2023 by the complainant, who is the victim of the, who is the brother of the victim. And thereafter, a case was registered on 12/11/2023, and investigation was started. Your lordship, in this case, the matter of fact is that the victim and the accused person, they are already known from it from before. They have already been in contact, and on fateful day during the month of October, when the victim was coming back from Bihar after attending the final rituals of the late father, when they reached Assam in Kokrajhar station, when they got down, your lordship, the victim asked for the mother's phone, and thereafter called the accused person, and they met up. From there, they eloped, your lordship. And
That means from Kokrajhar.
yes, your lordship. And after that, a complaint was lodged by the brother. So following this, your lordship, a compromise, an agreement has already been made by the communities, the Hindu communities and the Muslim communities, to that effect that they will withdraw the case. So we have also applied for bail, but if bail is granted, your lordship, we will follow appropriate procedures to quash the FIR in the meantime as well, to come to this honorable court for quashing the FIR. Your Honor, if bail is granted, your lordship, we are ready to provide reliable surety to the satisfaction of this honorable court. And we, as the accused person is a business person in Wokha, Nagaland, he has no flight risk. He will be able to attend as and when called by the police, and he will also make himself available during the investigation as well. However, your lordship, it is to be mentioned that the charge sheet has also been filed on 10/1/2024. Investigation has already been completed, your lordship. So on this basis,
He is in custody since when?
he's in custody since 12/11/2023. So your lordship, this is my humble submission.
His charge has already been framed or not yet?
Yes,
Okay.
charges have been framed. Before the sections, before the charge sheet was filed, he was booked under 366 of IPC, 120B of IPC. However, after investigation, he was booked under 366 and 4 of the POCSO Act. Your
Yes.
lordship, if I may take you to page 34, annexure C of my petition. The Wokha District Chamber of Commerce and Industry has made an agreement between the two parties.
Which page you have? seen?
Page 34, your lordship.
54. Yes, who made this agreement?
Yes, your lordship.
Agreement was made by whom?
Made between the Wokha District Chamber, since they are both the families belong to business community, businessmen. They are both from the business community of this town. They have made between the business communities, the Hindu and the Muslim communities, business communities, your lordship.
Yes. Government side from?
Yes, Your Lordship. As per order dated 5/7, LCR has been called, Your Lordship. Now,
Yes,
Your
we have
Lordship,
received
if Your
it.
Lordship, yes, Your
Definitely,
Lordship.
Yes.
If Your Lordship would peruse the record, and I think the statement of the accused, the victim is yet to be examined, Your Lordship. So, Your Lordship, and it is apparent, Your Lordship, from the petition that two bail application has been rejected by the lower court. Your Lordship, the order are not annexed here. However, Your Lordship, the petitioner should, Your Lordship, place on record on what ground and whether any fresh ground has arisen for the application of the instant petition, Your Lordship. That also has to be taken into consideration, Your Lordship. Otherwise, Your Lordship, before the examination of the victim, Your Lordship, the accused should not be released, Your Lordship. It will hamper since it's in the evidence
Have you
stage.
gone through the 164 of for the victim?
Your Lordship
164?
is yet to be examined, Your Lordship.
No.
164, Your Lordship, as per the charge. No, I have not gone through, Your Lordship, that because all the documents have been forwarded to the court. Prima facie case is firmly established, Your Lordship, as per the charge sheet, Your Lordship.
Cases, evidence is started, commenced, trial has been already commenced or not?
That's what I heard, Your Lordship.
Charge is already
Started.
framed now.
Yes, that's what I heard.
64. Good. Yes.
So your lordship, I have objection regarding the release of the accused, your lordship, because the sections are all levied against the accused are all non-bailable, and the grounds taken is not tenable, your lordship. On compromise, your lordship, that is not tenable in law.
Yes.
Like this lordship, in the, when the respondent number 2 appeared before the court below, he has also expressed his, he said he has no objection if the accused is released on bail, since there has been a compromise and between the parties. So he has the same prayer until now.
But have you gone through the 164 statement? She was taken up how forcibly he committed rape, on how many occasions, on multiple occasions, he had a sexual physical relationship with her. Those things are here. The compromise, I don't know on what basis the compromise was there, but obviously there are materials in 164. So anyway, yes, okay, heard. MS so and so, the learned counsel for the petition, and also heard your PP or PP, Marina,
As well.
as Marina, the learned PP appearing for the state response number 1, and MS your
Asna Longkamer.
says so and so appearing on behalf of the respondent number 2 slash the victim. For the victim or the informant?
Victim,
Victim.
who is being represented by the brother, who is the complainant.
The informant slash victim of this case. The scanned copy of the elsewhere has already been received. There is the same hard set. It is submitted by MS so and so that the accused petitioner and the victim had love affairs, and they knew each other since long. And on the day of incident, the victim along with her family members were coming down from Bihar after some religious who died? His mother.
Father.
After observing some religious ceremony of religious ceremony of his of her deceased father. When they reached at, she rang the present accused petitioner, and there from the Kokrajhar itself, she eloped the accused petitioner and they stayed together. But after their incident, the matter has been compromised in the intervention of some business communities, as both the petitioner as well as the victim belongs to the business community for healthy business. And though the victim and the accused person are from different religion, but the matter has been compromised, and matter has been already been compromised. Post more so, the accused petitioner hails from Nagaland, and there is no chance of absconding or evading any bail conditions, and will appear as and when the date is fixed by the court. She further submitted that the case has already been charge sheeted, and the charge sheet was filed on 10/1/2024, and the accused petitioner is in custody since 12/11/2023. And considering this aspect also vis-a-vis the compromise between the parties, he may be enlarged on bail. In this next para, in this context, MS so and so, the learned PP raised objection and submitted that the girl was admittedly a minor at the relevant time of incident, and the ground of compromise is not tenable under the eye of law, as the matter relates to POCSO, and accordingly she submitted that till the recording of the evidence of the victim, the accused may not be allowed to go on bail. There may be the post of further he submitted, there are no new or urgent ground brought in the petition, as the learned trial court below had rejected two numbers of bail applications earlier, considering the matrix available in the case record and case diary. Next para, MS so and so, the learned counsel appearing for the respondent number 2, submitted that case has already been compromised between the parties, and hence the respondent number 2 has no objection if the accused is released on bail. Next para, hearing the submission made by the learned counsel for both sides, I have produced the scanned copy of the case record and the other relevant documents seized along during the investigation. It is seen that the victim is stated to be a minor of 13 years of age, and accordingly her consent cannot be considered at this stage. In the same time, it is seen that there are sufficient incriminating material she brought against the accused petitioner while recording her statement under section 164 CRPC. And hence, I find that there may be hampering or tempering of the evidences of the PWs if the accused is released on bail at this stage before recording of the statement, especially before recording of the statement of the minor, so and so. In view of this, next para, considering the nature of the offense, I do not find it a fit case to extend the privilege of bail to the present accused petitioner at this stage, and hence stands rejected. Your petition stands rejected. Matter is disposed of.
For hearing, item number 10.
Lordship, item number 2, Your Lordship. The matter can come up on second, Your Lordship.
Yes,
The
Your
Office Party
Lordship,
have consulted.
I have a talk with my senior counsel and we can stick on September 2nd. But Your Lordship, let this be the last
This was
opportunity.
the item number 10.
Number 2,
No,
Your Lordship.
Item number?
2.
2, Your Lordship. The earlier item, Your Lordship.
Item number 2, dictation you are taking. Shabnam
Orders.
asked her to give it on 2nd of September.
Second, Your Lordship.
2nd of
Your
September.
Lordship, let this be the last opportunity since we have
Yes,
been
then
accommodating
also
for
asked
the
that
last
may be
several
considered
occasions.
The last opportunity for this.
Lordship, much
Okay.
obliged.
Much obliged, Your Lordship.
Yes, item number 10. Yes.
Lordship, this is a very short matter, and the issue involved in this lordship is whether in an application filed for recalling an order passed ex parte, the period of limitation will run with effect from the date of the order or with effect from the date of when it was brought to the knowledge of the party against whom that ex parte order is passed. That is the only issue, Lordship. May I take your Lordship to
Yes.
page 14?
Four zero.
14.
Oh,
This is short.
Yes, 1-4 order. This is the impugn order.
No, this is the order,
Oh.
the ex parte order to proceed with the case ex parte.
Yes.
This is filed in this dated 24/1/2013, passed in civil suit 14 of 2012. May I read out? Plaintiff present through counsel. Plaintiff prays that the case may be proceeded ex parte since the defendant has failed to appear even once despite summons issued through newspaper publication. Heard the counsel peruse the record and satisfied, pray aloud. The suit is hereby allowed to proceed ex parte, fixing this for plaintiff evidence, Your Lordship. Now, against this, Your Lordship, I have filed IA, next page. Page 15, IA Civil 112 of 2022, Your Lordship. Now, can I take Your Lordship to para 2, the grounds which I have taken?
Para 2.
Para 2, 3, let me just read out. The ground which I have taken in the IE. That the petitioner humbly states that during the mid part of 2012, the petitioner was residing in Humayunpur, New Delhi, but in the last part of the aforestated order of 2012, the petitioner shifted his residence from Humayunpur to another area in New Delhi, and since there was none in the Poi village under Ukhrul district of Manipur, this is where the paper publication was made, Manipur. The petitioner was wholly unaware about the suit, whereby the petitioner could not make his appearance before this honorable court and to contest the suit. Number 3, that since after the surge of COVID-19, the petitioner suffered irreparably and major setback in his business, leading to the closure of his business establishment in New Delhi, and he came back to his native village in Ukhrul district in the month of May 2021. Wherein the petitioner could come to know about the pendency of the civil suit 14 of 2012 before this honorable court. Number 4.
Yes.
That having come to know about the pendency of the suit, your petitioner made a contact with a lawyer at Dimapur, Nagaland, and upon obtaining the order dated 24/1/2013, which I've taken your lordship to your lordship, the petitioner had come to know that by the aforesaid order dated 24/1/2013, this honorable court was pleased to pass order for ex parte proceeding of the civil suit 14 of 2012. 5. That the petitioner humbly stated since the petitioner as defendant has not been in receipt of any summons stated to have been issued by this honorable court, so also the petitioner did not go through the newspaper which published the substitute summons to which the petitioner could not respond to the same, and such non-appearance before this honorable court was only due to non-receipt of information and unintentional, more so beyond control of the petitioner. That the petitioner is interested to contest the suit, and if the suit is proceeded, then the said ex parte much prejudice shall be caused. The order dated such and such accordingly, prayers were made to recall the order, your lordship. Now, page 21. This is the impugned order, your lordship. Page 21, annexure 3. This is the order passed by the Civil Justice Senior Division, Dimapur, Nagaland, in civil suit 14 of 2012.
Page 21. Page 21
Page
is your.
Annexure 3. Of pagination.
It's not the order. Order is at.
Or your lordship.
This is the petition.
Page. Hmm? 21, 2-1.
Not 2-1.
2-1.
Just this, order is annexed here.
And annexure 3.
Yeah, but somebody.
Yes, this is the order.
This is the order.
This is the order. This is the order.
Oh, order isn't other form. No, that's why I thought this is not an order.
This order.
Okay, okay.
Yes, this is the format.
Okay, this is the order. Okay.
Your lordship.
While writing the order also in the matter of such all the things are here, no?
No.
So I thought it is an.
No, lordship. Now,
Yes, then.
the operative, the portion starts from 23, page 23.
Yes.
Plenty, this is the format. Yeah, order dated 21/7/2012, date of hearing was this. The order. This order proposes to dispose of application registered as, this order is passed in the suit, main suit, but then in connection with IS Civil 112 of 2012, your lordship. Moved by the defendant petitioner to his learned counsel under section 151, surplusage praying for recalling of order dated such and such passed by this honorable court, wherein the defendant petitioner has been pleased to conduct ex parte. Case of the defendant petitioner. This is my case, your lordship. At the outset, the learned counsel drew this court attention to the cause title of the application and submits that it is well settled that mere non-mention. The petition ought to have been under order 9 rule 7, your lordship, but we are filed under 151. So that is what has been discussed. Non-mentioning of correct provision is not fatal to the application if the power to pass such an order is available with the court. As such, non-mentioning of the correct provision, which is order rule 9, Order 9, Rule 7 CPC in the instant application is not fatal, as this Honorable Court has the power to adjudicate this application for vacating the ex parte order. In support of a submission such and such. Next, Your Lordship. Next para. It is the case of the defendant petitioner that during the mid part of 2012, the defendant petitioner was residing in Himanpur, New Delhi. However, during the end of the same year, the defendant petitioner had shifted his residence to another area in New Delhi. And since then, no one was residing in the permanent residence at Poi village, district Ukul, Manipur. As such, the defendant petitioner was unaware of the present suit being filed, and for which the defendant petitioner had not appeared before the Honorable Court to contest the suit. It is submitted that defendant petitioner at no point of time received any notice stated to have been issued to him, and that substitute notice issued through paper publication had also not come to the notice of the defendant petitioner in as much as the same was published in the local Delhi newspaper in Manipur, because petitioner was residing at Delhi at that time, Your Lordship. When the defendant petitioner was still residing in Delhi, as such, the defendant petitioner could not appear before this Honorable Court. It is submitted that in view of the COVID-19 pandemic, the defendant petitioner has suffered irreparable loss in his business, resulting in the closure of a defendant petitioner business at New Delhi and subsequent migration to his native village in Ukhrul at Manipur in the month of May 2021. That's when the defendant petitioner had come to know about the pendency of the instant civil suit before this Honorable Court. It is submitted that defendant petitioner is interested in contesting the civil suit. As such, great prejudice would be caused to the defendant petitioner if the ex parte order or ex parte proceeding is not set aside and recalled. In support of his submission, learned counsel relied upon the decision of justice and further submits that after the order for proceeding with the suit ex parte against the defendant has been passed, there has been no progress in the suit, Your Lordship. It is important. And the matter is still at the stage of evidence by the plaintiff, Your Lordship. It has not proceeded. As such, no prejudice will be caused to the plaintiff opposite party if the ex parte order is vacated. And even if the defendant petitioner is not relegated to the position he would have been had he appeared and contested the suit, he would not be penalized in the sense of being forbidden to take part in the further proceeding of the suit. On the point of limitation, learned counsel submits that for vacating an ex parte order, there is no period of limitation prescribed, and the same is not hit by Limitation Act. In support of his submission, learned counsel relied upon this case. Now, case of the plaintiff opposite party. Learned counsel for the plaintiff opposite party at the outset draws his court attention to paragraph 3 of the affidavit of opposition filed by the plaintiff OP against the instant IA, wherein preliminary objection as regards maintainability of the instant IA has been raised, and submits that the instant application is liable to dismiss under the Limitation Act 1963. As the defendant petitioner had failed to challenge the ex parte order dated 14/1/2013 within the stipulated time period of 3 years from the date of passing of the ex parte order, Your Lordship. Now, may I take Your Lordship to the relevant part, page 28. There's a observation and finding of the court, Your Lordship. Page 28, second para. From what could be gathered upon, Lordship has got it. From what has been gathered upon of the citation relied upon by the petitioner defendant, it is seen that the law is clear on the point that there is no time period prescribed for filing an application under Order 9 Rule 7 CPC, which pertains to vacation of ex parte order. The law on the other hand is also clear that on the point that for cases where no period of limitation is provided, the period of limitation of 3 years from the date when the right accrues shall apply, and the same is provided under Article 137 of the Limitation Act, which is a residual provision. I have no issue on that. Last para. This court is not persuaded because 137 is extracted, Your Lordship. I have no issue. Last part, this court is not persuaded to rely on the judgment relied upon by the defendant petitioner and is in conformity with the decision passed in Sarjo Devi. The Honorable Court has relied on Sarjo Devi. I'll be placing that decision, Your Lordship. Such and such, passed by the Honorable High Court in such and such, wherein this court has relied upon the decision of this. Now, it is true that there's distinction between application file under Order 9 Rule 13. Order 9 Rule 13, Your Lordship, that is against ex parte degree, Lordship. And those file under Order 9 Rule 7, in that while the former seeks cancellation of degrees finally disposing of suit, the latter seeks cancellation of only orders setting the application ex parte, thus preventing him from participating in further proceeding in the suit. It is also true that unlike application under Order 9, Rule 13, there is no article in the Limitation Act providing any specific period of limitation for application under Order 9, Rule 7. Such application will be governed by Article 137, the residuary article which prescribes a period of 3 years. I have no issue on that, Your Lordship. Now, Your Lordship, may kindly this last paragraph, admittedly, Your Lordship may come. Admittedly, by filing the application under Order 9, Rule 7 CPC, no limitation is prescribed. It does not mean that an application under Order 9, Rule 7 to set aside the ex parte order can be filed at any point of time, that is, even after several years, as has been done in the present case on hand. Your Lordship may kindly note, order was passed on 2013. I have filed the application in 2012, Your Lordship, after coming back from Delhi. Since no limitation is prescribed under Order 9, Rule 7 CPC, like that of the Order 9, Rule 13, as observed in Rajaji's case, as well as in such and such case, the provision of Article 137 being residual provision alone would be made applicable, and therefore under Article 137 of the Limitation Act, the period of limitation is prescribed as 3 years, and since the application of such and such has been filed after a period of 3 years, it is clearly barred by limitation under Article 137 of the Limitation Act 1963, as rightly concluded by the learned translator, which according to this court does not require any indifference, and therefore the revision petition deserves to be dismissed. Now, in view of the observation made above, and on the strength of the aforesaid decision, taking recourse to the position that limitation period will be governed by such and such, is dismissed being barred by limitation. Since it is decided the instant application is barred by limitation, this court sees no reason for further discussion on the point as to whether ex parte order deserves to be vacated or not. Fix on this for marking of the documents, Your Lordship. That is the stage. No. Lordship, I have no issue on application of Article 137. That since there is no provision providing for a limitation period in the Limitation Act, Your Lordship. But my whole issue is from when it should be counted, the limitations should run. And maybe allowed to place this Sergio GB relied upon by the learned court below and 2 other divisions, Your Lordship. May I take Your Lordship first to Sergio's David case, Your Lordship. I'll be relying on para 4, 8, and 11. In para 4, Lordship has got it.
Some, yes.
List is
List
given,
will
Your
be-
Lordship. Now, may I take Your Lordship to the next page? Now, in last first column in para 4, there is petitioner file suit. That is there. Right? Next, Your Lordship may kindly see. Next date, 22/7/2010. Lordship has got it. In the next page, page 4, Lordship has got it. Fresh notice issued to respondent, defendant 2 to 4. Counsel for respondent, defendant 1 and 5 attended. The parties have attended. Next date, 28/20/2010, fresh summons were issued for respondent, defendant 6 to 12. Counsel for respondent, defendant 2 to 4 attended proceedings such and such. Now, 9/4/2011, date, Your Lordship may see, respondent, defendant 6 to 12. Your Lordship, you can rise after
Yes, yes, obviously. We'll hear to you. Act 2.
Lordship. Lordship.
Okay. Other side is also present?
Yes.
Okay. Continue.
Nissan cars না আমি এর লাইন কিন্তু পাইপ তো ভিজিট করে আসো এরানো তো আমি ফটো খিচিনা পাঠাবো আপনি এইটো আসা নাই কব আচ্ছা তো আপনি একে হোয়াটসঅ্যাপ চলাই দে ওকে ওকে আমি ইয়ে করবো দে No, madam, no, we get a little. But I'm going to need it. Okay. It is the main sound of the. Oh. Salah professional pada sini okay. So 1992 page as much as the model from by the attack of an Asian of Counsel base and the other professional. Nothing to do with law. Yeah, section this law. So, section article. So, law, muscle. This means all the law. Law is right, it's well. May I take your lordship to
Yes,
Sarjo Devi's case?
yes, Sarju Davis,
Sarju.
yes, yes.
Yeah.
You are stating on para 4, 8
Para-
and 11.
Paraphone. Now. Next table, your lordship may kindly see date 9/4/2011.
Yes,
Now, respondent defendant 6 to 12 were also served. The copies were also all served. Now, 10/10/2011, respondent defendant 2 to 4 and 6 to 12 were declared ex parte by this honorable court in such and such. Earlier occasion, they have appeared. Lordship. Now, 2012/2011, ex parte evidence of petitioner concluded. Even here, even evidence also taken in not in the present case, your lordship. Now the last column, lordship, may kindly see. 26/2/2015, counsel for respondent defendant 2 to 4 attended the proceeding and admitted the fact that no step has been taken by them to set aside the ex parte order. They were aware of the passing of the ex parte order. They have appeared, but they have not taken any step, no application filed for recalling the order, your lordship. Now the fourth table is 4/4/2016. Lordship is respondent defendant 2 to 4 filed an application under order 9, rule 7 to set aside ex only into 2016. They have filed the petition to recall the ex parte order, lordship. Now, In my respectful submission, Your Lordship, the facts in Sarjo Devi and the facts in this present case, Your Lordship, they're totally different. At no point in time, the petitioner were served a copy of the summons. Petitioner was not aware of pendency of the case, Lordship, the civil suit, Your Lordship. Now, he came to know about the pendency of the civil suit only on his return from Delhi to his native village in Ukru in the month of May 2021, Your Lordship, 2021. Now, even admitting that Article 137 is applicable, the 3 years period, in fact, in 2022, beginning of 2022, the application was filed. Your Lordship.
Application was filed on beginning of?
In the beginning, exact date, Your Lordship, I don't have, but it was in 2022, within months, whereas going by Article 137, we have 3 years, Your Lordship. Now, respondent has filed affidavit in opposition. May I take Your Lordship to the affidavit in opposition? I'll refer to only paragraph 4. It's a very short affidavit. Lordship has got it.
Para?
Para 4.
Page?
Para 4. Para 4, page 2.
No, here it is annexed.
Affidavit in opposition. Affidavit in opposition filed by the respondent.
Achha, okay. Para 2.
Para 4.
Para-
Lordship.
Yes.
May I read on? That with regards to the statement made in paragraph 4 and 5 of the revision petition, this deponent begs to state that the petitioners were good friends, both having social media accounts and had contacts. These are very relevant, Your Lordship, with each other through social media, even before and after filing of the civil suit 14 of 2012. Why I say this is relevant? Because he was aware that the petitioner, he was not in his native village, he was in Delhi. But where was the publication made? In the native village, Your Lordship. Apart from telephonic contact, the respondent plaintiff, after the civil suit number 14 of 2012 was filed, summon upon petitioner opposite parties was issued by the learner court below on 28/8/2012, fixing 10/10/2012. The respondent plaintiff have sent a summon through registered post in the 2 addresses, that is at Imphal and Delhi, to the petitioner, but the petitioner failed to appear on the date fixed, and as such, the respondent plaintiff have paid for substitute notice, which was allowed by the learner court below by order dated 25/10/2012. Accordingly, summon was served by the petitioner by way of substitute notice through paper publication, fixing 27/11/2012. It is pertinent to state herein that apart from substitute notice, the respondent plaintiff have uploaded the summon notice to the petitioner through social media, that is email, Facebook, and WhatsApp, which the petitioner have received and is fully aware of the case being filed against him. The petitioner has responded past comments to the summon notice posted by the respondent plaintiff on the Facebook as well as WhatsApp. Therefore, from the comments and the interaction between the petitioner and the respondent on social media, it cannot be said that the petitioner was not aware of the suit being initiated against him, and as such, this honorable court may not really, on the vague and concocted statement made by them, may not interfere by the petitioner. Now, extra copy is there. I have filed a reply to this, Your Lordship. My reply affidavit, just one paragraph, I'll read out, paragraph 5. Now, my reply to paragraph 4 of the affidavit in opposition in paragraph 5. Lordship has got it. that the statement made in paragraph 4 of the affidavit in opposition, which I have just read, as regards to the petitioner and the respondent having contact in social media after filing of suit number this is denied. The petitioner had never received summon or came across the substitute summon with regard to civil suit 14 of 2012. It is further denied that petitioner had received any summon or notice from the respondent through email or any other social media. The petitioner blocked the respondent from all social media platforms, including Facebook. As such, the petitioner has no knowledge about the summon notice being published on Facebook, which is marked as NHA 1 and 2 in the affidavit in opposition. The allegation that the petitioner was fully aware of the case being filed against him is denied. There is no proof that the petitioner had received the summon through email or Facebook. Also, with regards to the allegation that the petitioner was aware of the case being filed against him, it is pertinent to mention that the said interaction as annexed in Annexure A of the affidavit in opposition was made in the year 2022, when the petitioner came to know about the case being filed against him by the respondent. Now, specific denial is there, Your Lordship. Now, in my respectful submission, Your Lordship, now, I am not on Article 137, that since there is no provision as regards to the limitation period under the Limitation Act, where since no provision is there, Article 137, which is the residuary provision, that applies. But the only issue here is from when will that limitation period will run, whether with effect from the date of passing of the order ex parte or with effect from the date of the knowledge, Your Lordship. Now, in my respectful submission, Your Lordship, it should apply only with effect, the limitation period should run only with effect from the date of coming to know or passing of the ex parte order, Your Lordship. Now, as regard to authority case law, Your Lordship, I have searched, I have tried my best, but in spite of my effort, I couldn't, except in case of degree pass ex parte. It has been clearly laid down, the limitation should run with effect from the date of the knowledge, when the degree was, ex parte degree was passed, Your Lordship. And in my respectful submission, Your Lordship, the same principle should also be extended in case of ex parte order, Your Lordship.
Regarding the ex parte degree, have you annexed?
Lordship, I have got the case law is there. Lordship, this I have downloaded from 2021 SEC online, Gauhati 1735. Your Lordship has got it. Anima Boro, which is reported in 2021 to GLT 574. Lordship has got it. Lordship, I'll take Your Lordship to para 18. This is relevant. Mr. Goswami further submits that even if the plan was not served, the defendant respondent number 3 is supposed to file the petition for setting aside the ex degree within the prescribed period of limitation as the summons was duly served. The said submission is unacceptable to me. Article 123 of the Limitation Act 1963 stipulates a period of 30 days for setting aside a degree passed ex parte from the date of degree or where the summons or notice was duly served. Then when the applicant had knowledge of a degree, the word duly has its significance in answering the submission of Mr. Goswami. The Apex Court in such and such approved the meaning of the word duly as per Stroud Judicial Dictionary 4th edition, which is done in due course and accordingly to law. In Nahar such an enterprise, it was held that if the summons had not been duly served due to non-compliance of the provision of Order 5, Rule 2 of the CPC as per Article 123 of the Limitation Act 1963, the period of 30 days could not be counted. Lordship, this could not be counted from the date of degree, but when the applicant had knowledge of the degree, Lordship. In other words, the period of 30 days, the limitation period will run with effect from the date of the knowledge. It could not be counted with effect from the date of passing of the order, Your Lordship. Now, and in the affidavit, that statement also made that the petitioner had knowledge of the pendency of the suit. But I'll go one step ahead, Your Lordship. it is not the knowledge, but knowledge of date of hearing, which is material, your lordship. And in that connection, the another case law I place, your lordship, the third one, practical pharmaceutical. Practical pharmaceutical. Lordship has got it. It is reported in 2019 to GLR 202. Same para, lordship. Yes, GLR. Para 8, 9. Para 8, 9, your lordship. No, I'll just read the para 8 relevant portion, lordship. An objection was filed by the plaintiff asserting that the appellant had taken the recourse to forward as the facts regarding pendency of the money suit in question was very much to the knowledge. This is the stand taken of the appellant as in the suit filed by the appellant, namely money suit such and such. Now, may I take your lordship to para 24? Lordship has got it. In Sushil Kumar such and such, at para 10 and 11, the Supreme Court has stated as follows. The learned counsel for the landlord respondent submitted that there is an interpreter suit filed by the applicant because there was a dispute between the heirs of the original landlord, who unfortunately died, and his widow, and the grandson, who are the respondents herein. Each of the two was claiming itself to be the landlord and entitled to recover rent, setting up a will in this favor. The appellant had admitted in the plan therein that he was aware of the pendency of the suit filed by the respondent in the court of the rent controller Amit Shah. In fact, this admission of the appellant had weighed heavily with the High Court, which has opined that even if the summons was not duly served, the appellant was aware of the pendency of the suit, and therefore the application under Order 9, Rule 13 CPC did not have any merit. The High Court has overlooked the second proviso, Rule 13 of Order 9 CPC, added by such and such amendment, which provides that no court shall set aside a degree past ex parte merely on the ground that there has been an irregularity in the service of summons, if it is satisfied that the defendant had notice of the date of hearing, your worship, and had sufficient time to appear and answer the plaintiff's claim. It is the knowledge of the date of hearing, and not the date, not the knowledge or pendency of suit, which is relevant for the purpose of proviso above said, your lordship, on limitation. 25. From the above, it is manifestly clear that it is the knowledge of the date of hearing and not the knowledge of the pendency of the suit, which is relevant for the purpose of considering the application under such and such. What I'm trying to impress upon your lordship is that in the first place, the petitioner had no knowledge about filing of the pendency of the suit, your lordship. But in the affidavit, they're saying that it was brought to my knowledge. But no, what is relevant is not knowledge about pendency of the suit, but knowledge about the date of hearing, your lordship. Now, may I take your, that is all my submission. May I take your lordship to the prayer? My prayer is at page 11. Lordship has got it, page 11, 1.
Yes.
Yes. In the above said premises, it is therefore prayed that your lordship may be pleased to admit this petition, call for the record, issue notice to respond to show cause as to why the impugned order dated such and such passed by the learned Court of Civil Justice in Division Dimapur, Nagaland in IN number 112 of 2022 shall not be set aside or quashed, and after hearing the parties, be pleased to set aside and quash the impugned order and pass necessary order as this honorable court may deem fit and proper. So this is my prayer, your lordship. So just to sum up, your lordship, the petitioner at no point of time had received summons. Therefore, he was not aware of the pendency of the suit before the Court of the Civil Justice Senior Division Dimapur, your lordship. And even the paper publication which was made by the respondent, it was made in this native area, whereas the petitioner at that point in time was in Delhi, your lordship. So only after coming back from Delhi in the month of May 2021, he came to know about the pendency of the suit. and on inquiring through his counsel at Dimapur, came to know about passing of the ex parte order. Accordingly, the petition was filed, but as by the impugn order, that application for recalling the ex parte order was dismissed on the ground that Article 137 will apply. I have no issue on that. Article 137 Limitation Act will apply, but I'm more on from when will the limitation period will run, whether with effect from the date of passing of the order, ex parte, or with effect from the date of when it was brought to his knowledge, Your Lordship. So in my respectful submission, the limitation period ought to run when it was brought to the knowledge of the petitioner and not with effect from the date of order. Accordingly, Your Lordship, my prayer is that the petition, the impugn order is liable to be interfered with. Oblige, Your Lordship.
May I please, my ladyship?
Just sorry, Your Lordship. In fact, Your Lordship, even if it is allowed, no prejudice will be caused to the, because it is only a stage of marking of documents, exhibits only. No evidence, nothing has been taken. Oblige.
My ladyship, may I be allowed to take your ladyship to page number 24 of the petition, my lord? The case of the plaintiff. This was the case of the plaintiff before the trial court, learned trial court.
Yes,
Page number 24.
yes.
The case of the plaintiff, last married. Learned counsel for the plaintiff, opposite party at the outset draws this court's attention to paragraph 3 of the affidavit opposition filed by the plaintiff, opposite party against the instant IA, wherein preliminary objection as regards the maintainability of the IA had been raised and submits that the instant application is liable to be dismissed under the Limitation Act 1963, as the defendant plaintiff had failed to challenge the ex parte order dated 24/1/2023 within the stipulated period of 3 years from the date of passing of ex parte order. It is submitted that application for vacating the ex parte order has been preferred after a lapse of more than 9 years. It is further submitted that no condemnation application had been moved by the defendant petitioner as contemplated under the Limitation Act 1963. Hence, it is submitted that the instant application is liable to be dismissed on this ground alone. It is submitted that the defendant petitioner has suppressed material facts and has approached this honorable court with unclean hands. It is submitted that the plaintiff, opposite party, and the defendant petitioner are in constant touch with each other through social media and telephonically, and as such, the defendant petitioner is aware and had the knowledge of the present recovery suit being filed by the plaintiff opposite party against the defendant petitioner. In support of her submission, the counsel relied upon the WhatsApp chat between the plaintiff and the defendant petitioner. What I'm coming to this point is the petitioner was fully aware about the summons being issued by the learned trial court, but he purposely avoided and did not appear before the trial court, despite having the full knowledge. And in my affidavit in opposition, my lord, my ladyship, I've annexed the WhatsApp chat and the email. The
Affidavit in opposition.
yes, my ladyship, page number 6. Page number 6. Page number 6 is the summon letter. The type copy is at next page. This was uploaded in the Facebook. And the next page is the yes, madam. This is the this was uploaded on 2nd November 2022. The type copy is at the next page, page number 9. The
It
DS
was uploaded in 2nd November 2022.
2012, before 2022. My learned friend is saying that the petitioner came to know about this only in the year 2022, but whereas he was fully aware before that also.
In which date you want to say?
2nd November 22,
Huh?
2012. Page number 8.
on the top, DTS in 2nd November 2012. The type copies at the next page, though the pictures maybe not. And the last page, page number 10. This is the WhatsApp chat between the petitioner and the opposite party. Here. This is the second last paragraph is the reply of the petitioner. Sure, let me pay with interest if the court decides on your favor. He's specifically mentioning about the court. That means he was fully aware about the proceedings. That's how the
The
learned
conversation was 9:29 PM on which date?
2012.
2012?
So what I'm saying, the petitioner was fully aware
This
of
conversation was on 2012.
it.
Not yet.
This Facebook page number 8 was in page number 8 was in 2012.
And 10 then?
And then this, there's not date, but it shows that the petitioner was fully aware. Just to show this before this honorable court that the petitioner was fully aware of the proceedings, not about the order passed.
This was placed before the learned trial court below also?
Yes, madam, my lordship.
But
That's why
is
I've
there
read
any
the
authenticity of these things?
yes, my lord. That's why I've read the order, impugn order about the condition. The petitioner was fully aware of the proceeding, first thing, my ladyship. Secondly, the limitation for filing an application is 3 years as per Article 137 of the Limitation Act. And if any application is filed for against the order after the prescribed limitation period, an application under Section 5, paying for condemnation of application, has to be filed, which the petitioner has not opted. His ladyship is fully aware about Section 5 of the Limitation Act. So no application under Section 5 was filed. Just that application for restoration of the ex parte order. And which my letter friend, which she have relied on the judgment, it says about the degree, not about the proceedings. About the degree, order pass, final order. But this impugn order was an order to proceed ex parte, not the final order. Just since the petitioner was issued summoned, he has failed to appear despite his knowledge. That's why sufficient opportunity was given, but failed to appear. So the learned trial court has directed only to proceed ex parte. No order or no degree has been ordered, only to proceed. And then the petitioner was fully aware about the proceedings. Now coming after about 9 years, more than 9 years after filing of the petition, the petitioner is saying that he was not aware about the proceeding nor about the order pass. If that ground can be taken, that anybody can come at any stage of them saying that I wasn't aware. Why I'm saying is because he was fully aware about the proceedings as per the social media chains. So he cannot say I was not aware. It was the duty bound of the petitioner that if he was aware, then he could have taken the updated from the court about the status of the case, which he has not done. He just remained silent. And then after 9 years, he's saying I wasn't aware of the order. That is not justified. I may be allowed to rely on one judgment, 2013-14 SCC 81. page 81. One. Page 81, paragraph 12, 13, and 15. Mary Molly.
Yes.
Paragraph 12. It is a settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes. The court has no power to extend the period of limitation on equitable grounds. A result flowing from a statutory provision is never an evil. A court has no power to ignore that provisions to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. The legal maxim, dura lex sed lex, which means the law is hard, but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. The statute of limitation is founded on public policy. It aims being a secure peace in the community, to suppress fraud and perjury, to quicken diligence, and to prevent oppression. It seeks to bury all acts of the past which has not been agitated, unexplainable, and have from lapse of time because become stale. According to Halsbury's Law of English, volume so and so, Policy of Limitation Act, the court have expressed at least 3 different reasons supporting the existence of statutes of limitation, namely that long dormant claims have more of cruelty than justice in them, that the defendant might have lost the evidence of disproof a stale claim, and that persons with good cause of action should pursue them with reasonable diligence. An unlimited limitation would lead to a sense of insecurity and uncertainty, and therefore limitation prevents disturbance or deprivation of what may have been acquired in equity and justice by long enjoyment, and or what may have been lost by a party's own inaction, negligence, or laches. Paragraph 15. The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to why, what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for what of bona fide on his part in the facts and circumstances of this case, or found to be not acted diligently or remain inactive, there cannot be a justified ground to condone the delay. No court be justified in continuing such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the continuation of delay. In case where there is no sufficient cause to prevent a litigant to approach the court on time, continuing the delay without any justification, putting any continuation whatsoever amounts to passing an order in violation of the provision, and it then amounts to showing further disregard to the legislature. Why I'm coming to reading this is, my lord, the petitioner was fully aware of the proceeding. And then by filing an application for restoration of the order, ex parte order, he would have filed an application showing sufficient cause reasons why he could not file on time, but that was not done. Just an application for recalling of the order. No application for condemnation was filed. And then even the petitioner has stated that he was aware of the proceeding. So he was fully aware that what order is to be passed in the proceeding. So it has the diligent power. It is a duty of the petitioner to be diligent. He was aware that if he doesn't appear in the given date, what will be the order passed? That is an ex parte order will have to be passed. It's not a final judgment, final degree order, but to proceed ex parte. So the petitioner was aware of the proceedings, which means the limitation period has to be counted from, even if it is to be counted from the date of knowledge. The petitioner was fully aware, had the knowledge about the proceedings. So it is the application of the petition is hit by the Limitation Act. That is all I have to say.
All right, just short reply. On not filing application for continuation of delay. The learner counsel here has referred to section 5, need to file an application for continuation of delay. So on that, your lordship, I'm relying on 2010, volume 12 SCC 159. Para 12 and 13. Married. It is to be seen here that the question of delay was completely interlinked with the merit of the matter. The applicant defendant had clearly pleaded that they did not earlier come to the court on account of the fact that they did not know about the order passed by the court proceeding ex parte and also the ex parte degree which was passed. It was further clearly pleaded that they came to know about the degree when they were served with the execution notice. This was nothing but a justification made by the appellant defendant for making Order 9 Rule 13 application at the time when it was actually made. This was also a valid explanation of the delay. The question of filing Order 9 Rule 13 application was, in our opinion, rightly considered by the appellate court on merit, and the appellate court was absolutely right in coming to the conclusion that the appellant defendant was fully justified in filing the application under Order 9 Rule 13. This is for vacation of degree, your lordship. CPC at the time when they actually filed it, and the delay in filing the application was also fully explained on account of the fact that they never knew about the degree and the order starting the ex parte proceeding against them. If this was so, the court had actually considered the reason for the delay also. Here in my petition, I have given the reason, but that was not considered. Under such circumstances, the High Court should not have taken the hyper-technical view that no separate application was filed under Section 5. Just like in the present case, no separate application under Section 5 was filed. 13. The application under Order 9 Rule 13 CPC itself had all the ingredients of the application for condonation of delay in making that application. For a time being, may I take your lordship to Order 9 Rule 13. What does Order 9 Rule 13? That is CPC.
Yes, good.
Order 9 CPC.
It's IPC, CPC. give me.
CPC. CPC, you have the CPC. This relates to ex parte degree, your lordship, but as I've said, the same principle should also be extended in case of ex parte order. That is my case. And as per this, the issue laid down by this, as per this, your lordship, the principle of law laid down is that, like, it is inherent in the provision, Order 9 Rule 13, that itself is, may I read out, your lordship? In any case, Order 9 Rule 13. In any case in which a degree is passed ex parte against a defendant, he may apply to the court by which the degree was passed for an order to set it aside. And if he satisfies the court that the summons was not duly served, in the other provision more liberal, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the degree as against him upon such term as to cost, payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. So the Honorable Supreme Court in this case says that it is there itself in the provision. Now, Order 9 Rule 7 is more liberal in language. Order 9 Rule 7 is more liberal, your lordship. Procedure where defendant appears on day of adjourned hearing and assign good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assign good cause for his previous non-appearance. Only that one. not regarding nothing specific as in 913 is mentioned. Assign good cause for his previous non-appearance, he may, upon such term as the court directs as to cost or otherwise, be heard in answer to the suit as if he had appeared on the day fixed on his appearance, your lordship. So it's just because in the present case, an application under Section 5 of the Limitation Act bringing for condemnation of delay has not been filed, your lordship, as per the principle of law laid down by the Honorable Apex Court, your lordship. Hyper-technical view should not be taken, your lordship, because the condemnation, the ground itself is here. If in the petition, the ground is taken, here, I have taken the ground that because of, like, he was in Delhi, he was not aware, substitute summons was served in his native village. So all those grounds were taken. So since the grounds for the reason has been assigned for not appearing, just because a separate application under Section 5 Limitation Act has not been filed.
But they have also pressed on the WhatsApp message or the social media.
Lordship.
What about they were saying that
He-
they have already annexed the 2-3
Yes.
messages with the communication with you.
And second, your lordship, on WhatsApp message. First, it is incumbent on the part of the plaintiff, now respondent, to ensure that someone is duly served. That first part he has not done, lordship. Because the paper publication which was made was not in Delhi where the petitioner was.
That you have already submitted.
Lordship. And now, without taking due steps for causing service, now the petitioner is relying on WhatsApp message, which I have denied. And it has not been established. There's no proof that I have received the message. What if tick mark is there? The tick mark means he has sent it, whether I have received it or not. And which I have categorically, I've denied in my reply affidavit, para 5 from my reply affidavit, your lordship. Now on the authority relied upon 2013-14 SCC 81, your lordship. The issue is not about extending the period of limitation. Court cannot extend the period of limitation, your lordship. The issue is not that. Here the issue is with effect from which date the period of limitation should run. And therefore, your lordship, the authority relied upon by my learned friend, your lordship, it is irrelevant so far as this case is concerned. Well, if the petitioner is praying for extending the period of limitation, then yes, because court cannot. And that the issue of this case will apply, which has been relied upon by my learned friend. But petitioner before your lordship is not about praying for extending the period of limitation, but on the issue to decide with effect from which date the limitation will run, whether with effect from the date of ex parte order or with effect from the date on which the petition, the order was brought to the knowledge of the petitioner. That's the only issue. Obligation.
Most of the date, the petitioner came to know about the proceedings.
And in all fairness, your lordship may kindly take also consider this aspect of the matter that no evidence is taken. Now it is only at the stage of exhibit, your lordship, marking of documents. So even if the matter is remanded back by setting aside the order and to dispose of the matter on merit, allow me to participate, that will serve the interest of justice. Your
Allow you
lordship.
to participate in a sense, you have not filed your written objection also, written statement.
No, your lordship. Oblige, your lordship.
Yeah, keep it reserved. I'll pass the order. Reserve it, I'll pass the order. And here, from here, this one, see, 2013 or what is this one, 14, you make out a printout here and give me. Probably book will send. And keep this one Keep this one with the record, huh?
We have one more matter.
Yes, I know. Reserve, keep it reserved. Yes, right. From whom? Who is the council? To call for the time, please. Item number?
11.
For hearing, item number 11.
Lordship, if this matter can be fixed on trust day, 8. I've taken the consent from the opposite parties.
Other side. I don't know
Yes.
Thursday, how many matters they have. Is there any cause list for the Thursday? No, not yet for Thursday. Can be fixed on Thursday? Okay, at the request made by the learned counsel for the petitioner, with the consent of the other side, prayer for adjournment, prayer is allowed, this accordingly on Thursday. Thursday
Yes,
is
Lordship, as a fixed item, 8. Trustees, 8.
8. Is it 8? Thursday, 8.
8, Your Lordship.
This accordingly on 8.
Must be your lordship's first visit to
Yes, first visit to Kohima.
Kohima
Yes,
bench.
first visit.
Welcome to Kohima bench, your lordship.
Thank you.
It's a very young bar, your lordship, though court is very old,
Ah.
mostly young lawyers.
Most of them are young lawyers. You are practicing both in the district court. District court is how far from here?
It's not far, but just about maybe 3 kilometers.
Okay.
Except for the traffic, Kohima,
Oh,
it takes time.
This takes time.
It takes time.
So the advocates who generally practice in high court, they used to practice in high court only.
Mostly.
Uh-huh.
Mostly.
I have heard that there are civil matters are more in comparison to criminal matters.
Yes.
Civil matters are more, no?
Civil matters. And your lordship here, we get very few cases from this thing, from district court. Maybe these are very few, these are the cases. Otherwise, most of the cases, we have our local laws, people, they go and then there are also extra constitutional court.
Yes.
They decide.
Petitions also there.
Yeah, so mostly we survive on writ.
Writ.
Writ only.
Writ only.
That is only case.
Oh. This is my first visit. Otherwise, I had a pleasant stay there, and I am staying at the bungalow when this is a old bungalow, I think, for a 42, I think, 42 or something, yes. So atmosphere is good. Yeah, in Gauhati, we are just it's terribly hot there in Gauhati. Even it reaches to 40, 41 degree also.
Sudden changes constitution, otherwise lordship wouldn't have been here. Right?
Pardon?
The change in constitution. Or no, is it okay? Yes. Because I was under the impression that Justice Bodhi Habung is sitting, but lordship, there was a change in the constitution, lordship has come. And
No. Just my roster duty was
Roster,
here only, in
roster.
fact. Habung is there here only. So Habung most probably next, his benches will be at Gauhati, I think.
Gauhati.
So he left yesterday, I think. So that's okay, we'll last meeting. Oh. Thank
Consider what consider there. By a side. Hello. Jawan is not the guest, but the job and the side project, not pro, imam with Jawan. Jangan dan itu kata jauh lagi tu. Hah? Baik.